Tiffany Edwards.
Morning.
Right away, the hearing opens with what might sound like routine courtroom chatter. But there's actually an important legal strategy unfolding here. The defendant is preparing to enter a no-contest plea, and the defense attorney briefly hints at the reason: civil liability. That's a big clue about what's happening behind the scenes. A no-contest plea, also known as nolo contendere, allows a defendant to resolve the criminal case without formally admitting guilt. For the court, it's treated the same as a guilty plea when it comes to sentencing. But outside the criminal courtroom, especially in civil court, the difference can be very significant. If the alleged victim later files a lawsuit seeking financial damages, a guilty plea could be used as direct evidence of wrongdoing. A no-contest plea generally cannot be used the same way. So what you're seeing here may actually be a carefully calculated move by the defense to limit future financial consequences. Another thing to notice is the judge's calm, procedural tone. Judge Simpson runs a very structured courtroom, and that structure is about to become clear as he walks through every legal right the defendant is giving up. Plea hearings may look simple, but they are built on strict legal safeguards designed to ensure the defendant fully understands what they're doing. And as this case unfolds, think about this question. If you were facing criminal charges that might also trigger a civil lawsuit later, would you risk going to trial? Or would you resolve the criminal case first to control the damage? Because sometimes the courtroom battle isn't just about guilt, it's about strategy.
This is date and set for final settlement conference. People are ready to proceed. There is an offer in this case to plead as charged under prosecutor's deferred, reserving restitution. My understanding is that that offer will be taken, and this will be a no contest plea. It is just basically send a police report over to court.
The reason for the no contest plea, Your Honor, obviously from the nature of the charges, there is a potential for civil liability. All right, very good. And Ms. Willenbringer had provided me previously with a copy of the police report, and I have no objection to the court reviewing it for purpose of this plea.
May I have her sworn, please? You raise your right hand. You swear to affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
I do.
You lower your hand. State and spell your name for the record.
Tiffaniedwards.
All right. Ma'am, it is this court's understanding that you're going to plead no contest to the charge of malicious destruction of personal property, 200 to 1,000.
Yes.
Correct. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. The fine could be increased if 3 times the value of the property taken or that was destroyed. If that is greater than $2,000, that would become the maximum fine. Do you understand that?
I do.
All right. Do you understand what a no contest plea is?
I do.
All right, let me explain 2 things about a no contest plea to make sure that you understand. The first thing you need to understand about a no contest plea is it means that you're not further desirous or wanting to contest this charge. You understand that?
I do.
Second thing you need to understand is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that?
I do.
All right. Still wish to plead no contest?
Yes.
And to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
I do.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
This section of the hearing may sound repetitive, but legally it's one of the most important moments in the entire process. Judge Simpson is carefully listing every constitutional right the defendant is about to give up by entering a plea instead of going to trial. First, there's the right to call witnesses and present a defense. Then there's the right to confront and cross-examine witnesses, which is one of the strongest protections in the American justice system. The defendant is also giving up the right to remain silent, meaning the prosecution will no longer need to prove the case beyond a reasonable doubt in front of a jury. And finally, the defendant gives up the presumption of innocence, that powerful legal principle requiring the prosecution to prove guilt before punishment can occur. It might seem surprising how many rights are waived in just a few sentences, but courts must confirm that defendants understand this fully. If a plea is entered without proper understanding, it can later be challenged and even overturned. Another interesting point here is how calm and direct the judge remains while explaining these consequences. That's intentional. Judges avoid emotional language and focus strictly on the legal process, so the record clearly shows the defendant made the decision voluntarily. But here's something worth thinking about. Do you believe most defendants truly understand the long-term impact of giving up these rights, or do the pressures of the courtroom sometimes push people toward quicker decisions? Because once a plea is entered, the path forward becomes very different.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty or plead no contest?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
I am.
The court has been provided Pittsfield Township Department of Public Safety report for their case number 22-15063. Any objection to the court reviewing that to form the factual basis?
No, Your Honor.
Reviewing the report, one thing that I was looking for is in terms of value, is there a stipulation that it's greater than 200?
For purposes of the plea, Your Honor, yes.
All right. With that stipulation and with the review of the police report, the court does find that there is a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
We're satisfied.
I'm satisfied, Your Honor.
Court will accept the defendant's plea of no contest to this. Defendant is referred to probation for a pre-sentence investigation and report and consideration of restitution. Sentencing in this matter will be.
September 13th.
Your Honor, I have to ask this question. Are you still doing Zooms or are these live?
It would be by Zoom. Is that a problem?
I've got a jury trial scheduled that week, Your Honor, and I could probably.
We can give you another day.
Yeah, I can.
That's fine.
October 11th.
That work?
Yeah, wait a minute. Oh, I'm sorry, I'm in November. I started saying 11th is a Saturday. I'm in November. Hang on. I'll show up on the 11th.
Yeah. I'm here.
Yeah,
So,
that-
October 11th.
That's
work?
fine. Yeah,
All right.
that's fine.
Sentencing October 11th, 2023, 9 a.m. That will be via Zoom.
Now we reach the moment where the court schedules sentencing, and this is where the consequences of the plea will ultimately be decided. The judge refers the case to probation for what's known as a pre-sentence investigation, often called a PSI. A PSI is essentially a deep background evaluation of the defendant. Probation officers gather information about criminal history, employment status, family background, and sometimes even the defendant's mental health or substance use history. They also examine the impact of the crime on the victim. All of this information is compiled into a report that helps the judge determine an appropriate sentence. This step is important because sentencing isn't just about the crime itself. It's also about the individual who committed it. Why two people could commit the exact same offense but receive different sentences depending on their background, prior record, and level of remorse. You may also notice that the sentencing hearing is scheduled via Zoom, which has become increasingly common in many courts since the pandemic. Remote hearings allow courts to manage busy dockets more efficiently while still maintaining due process. But it also raises an interesting debate. Does holding sentencing hearings remotely reduce the gravity of the courtroom experience, or does it simply make the justice system more efficient? Let me know what you think.
Thank you, Your Honor. May I just briefly respond?
Yes, you may.
Your Honor, we did meet with the victim today. He told us that he believed defendant was kind of glaring at him in the lobby today. So I just want to ensure that defendant is aware of what contact, no intimidating or threatening behavior means, and I just want to ask the court to remind defendant of those conditions.
Your Honor, I was hoping we wouldn't get into this, and I've confirmed this with security out in the lobby. When my client came in, she went to the window because she wasn't sure where to go in this building. The so-called victim started an incident. He had to be restrained, not physically, but he had to be restrained by the security. I've confirmed that with them. He's the one that started whatever happened out in the lobby.
Okay.
I don't have that information, Your Honor, and given that defendant just took a plea, we no longer have a so-called victim, we have a victim in this case.
All right. Here's what I'm going to do. Ma'am, I would just admonish you to, regardless, I guess, of how it starts, to try to conduct yourself and get yourself out of that situation in a way and not have any contact with the victim in this case. Is that understood?
Very clear.
All right. The other thing is the victim present in the courthouse
Yes,
Or
Your Honor.
Have they left?
Oh, he's here. Well, at least it was when I walked up to the podium, he was here.
Do we know?
I can ask Mr. Ronnie.
Okay, please do, because what I'm gonna do is I want him out. I'm gonna have you wait, and then once we're assured he's gone, then you can leave the building, okay?
This moment might seem minor, but it actually reveals how judges sometimes have to manage conflicts that happen outside the courtroom as well. Earlier, there was an allegation that the defendant may have been glaring at or intimidating the victim in the courthouse lobby. The defense countered by claiming the victim actually started the confrontation and had to be restrained by security. Without clear evidence of what happened, the judge takes the safest possible approach, separating the parties completely. By asking the defendant to wait until the victim leaves the building, the court removes the possibility of another confrontation. Judges often use these small logistical decisions to prevent tensions from escalating into something more serious. Remember, courthouse hallways can be emotional spaces. Victims, defendants, families, and attorneys are often all gathered in the same area, and emotions can run high. This decision isn't meant as punishment. The judge even says so directly. It's simply about maintaining order and ensuring everyone leaves safely. And it raises an interesting point for viewers. Should courts take stronger steps to keep victims and defendants separated during hearings? Because sometimes the most volatile moments happen outside the courtroom doors rather than inside them.
Okay.
Not as a punishment to you, but I'm just looking at not having anything start up front. Okay, so let's check. Yes. So ma'am, you can have a seat. We're good.
Your Honor, does she need to stop at probation?
She does need to stop at probation, but I don't want her leaving the
I
court
understand.
right now. until-
Probation down the hall to the left, you'll see a sign. You need to make an appointment. They do need to do a background. It's part of the process that I discussed. They have to do a background check on you.
Oh, okay, so it's,
Just wait till they say it's okay, and then just go on.
Have a seat in the back.
Sure. Well, I can't do anything because. Okay, and where is Fink's other side on his case?
Yeah, she's right there, Your Honor.
Where's she? Oh, there you are. Okay.
I'm not sure what you asked, so I apologize.
Well, I was wondering where you guys were on yours.
You.
Doesn't everybody? All right. Okay, we'll wait.
Assistant Public Defender Calvin Hawthorne, appearing with and on behalf of Alexei Makovic. Mr. Makovic, please state your name.
Alexei Makovic.
Your Honor, we're here at final settlement conference. People are ready to proceed. Defendant is kind of eligible. He was 20 at the time of this, so there will be a plea.
That is a correct statement, Your Honor.
Very good. May I have him sworn?
Raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, about the truth?
Yes.
And lower your hand. State and spell your record.
Alexei Makovic, ALEKSEI MAKOVIK.
Sir, this is court's understanding you're going to plead guilty to the charge of assault and or assault and battery. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes, I do.
Still wish to plead guilty?
Yes,
And to that charge, how do you plead?
guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes,
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court order their appearance. You're also giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. Do you understand that?
yes,
You understand you're giving up your right to appeal of right.
yes,
Are you on probation or parole?
no,
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
no,
Anybody threaten you or coerce you?
no,
You're doing this voluntarily
yes,
of your own free will
yes,
and because you believe that you are indeed guilty.
yes,
June 21st, 2023, at the location of 2979 Silver Spring Drive, Pittsfield Township, Washtenaw County, State of Michigan. What'd you do on that date involving a Marina Makovic that makes you think that you're guilty?
I pushed her.
All right. Didn't have her permission to do that, did you?
No, I did not.
All right, and you did that intentionally?
Yes,
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Defense is also satisfied, Your Honor.
The court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for pre-sentence investigation and report and consideration of HIDA. Sentencing in this matter will be 9 a.m. That will be via Zoom.
Right down the hall.
All right. Probation's right down the hallway to be on your left. At the, basically the very end of the hallway here. All right. Thank you. Bond will continue. Yep. Are they, is he out of the building yet?
I was discussing that with the
Okay, okay, so what's the problem?
So can I just approach briefly, Ryan?
Yes.
Your Honor, John Vincent on behalf of the defense. Guys, take a date and time set for a settlement conference. However, I do believe we have come to an arrangement where Mr. Carter will plead. If I could have the prosecutor read the offer on the record, or I can do it.
That's correct, Your Honor. If he does plead guilty to this case, he also has a child abuse case in which he will be pleading guilty. Then he has 2 pending felony matters, and those will be reduced to misdemeanors.
Got it. Okay.
That is our understanding, Your Honor.
So he's gonna plead guilty to this case and then
Then on the 16th.
on the 16th, he's before me on the child abuse case.
That's
He's gonna
correct.
Plead guilty on those.
Now the courtroom transitions into a far more complex situation involving a defendant named Mr. Carter. Unlike the earlier cases, this one is tied to multiple charges across different proceedings, and that's why the attorneys are discussing something called a global resolution. A global resolution is essentially a coordinated legal strategy where several cases are handled together rather than separately. Prosecutors and defense attorneys sometimes prefer this approach because it allows the court to evaluate the defendant's overall conduct rather than isolating each incident individually. What makes this case particularly notable is the mention of child abuse charges and felony matters that are still pending. That means today's plea is only one piece of a much larger legal puzzle. The attorneys are essentially setting up the timeline for how all of these cases will eventually be addressed. This kind of coordination is common when a defendant has several active charges. Courts want to avoid inconsistent outcomes, and defense attorneys often negotiate plea agreements that account for every case at once. But it also raises an interesting question for viewers. When someone faces multiple charges across different cases, should the justice system evaluate them together? Or should each case stand completely on its own? Because sometimes the bigger picture can dramatically influence the outcome.
Then he's before me on 2 felony charges that are gonna have a reduction in plea.
Presumably at a PCC, yes.
Got it.
That's correct.
When did we set those?
That's the 16th for the child abuse. I don't know when the PCC is at.
We might have set those right after. I think I was waiting on the 16th and then I set them out. The 24th, I bet.
Yeah, 24.
I bet you I set them. Okay, so I'll be seeing Mr. Carter a bit here. All right. Sorry. May I have him sworn?
Raise your hand. Do you swear or affirm the testimony you're about to give? Lower your hand.
Sir, it is this court's understanding that you're going to plead guilty to the charge of domestic violence. Is that correct? That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that? Still wish to plead guilty?
Yes.
And to that charge, how do you plead? Now, you understand that by pleading guilty, you'll not have a trial of any kind. Because of that, you're giving up your right to call witnesses to speak to you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt.
Once again, Judge Simpson walks through the familiar but critical process of confirming the defendant understands the rights being waived by pleading guilty. At this point in the hearing, this explanation might sound similar to what we've already heard earlier in the session. But legally, every plea must be individually verified. The judge cannot assume the defendant understands the consequences just because similar explanations were given in previous cases. What stands out here is the seriousness of the charge being discussed: domestic violence. Even though this offense is technically classified as a misdemeanor, courts treat these cases with heightened scrutiny because they involve personal relationships and potential ongoing risk to victims. Domestic violence cases often involve emotional dynamics that make them very different from other criminal offenses. Victims and defendants may share homes, families, or financial ties, which can complicate the legal process significantly. That's why judges carefully verify that the defendant's plea is voluntary and that the factual basis of the offense is clearly established. And that factual basis is about to come in the next moment, when the defendant explains exactly what happened.
You understand you're giving up your right to appeal outright. Are you on probation or parole? Has anybody promised you anything other than what's been stated here today to get you to plead guilty to this charge? Anybody threaten you or coerce you? You're doing this voluntarily and of your own free will? And also because you are guilty of this offense? On February 17, 2023, at the location of 3024 Woodland Hills Drive, apartment 28, Pittsfield Township, Washtenaw County, State of Michigan. What did you do on that date involving an Image Boone?
Grab her by the cheek and smushed her.
Say again?
Grab her by the cheek and mushed her head down.
All right, you didn't have her permission to do that, did you?
No, sir.
And you did that intentionally?
This brief exchange may sound simple, but legally it provides the entire foundation for the domestic violence charge. In criminal law, prosecutors must prove several key elements to establish assault or domestic violence: intentional physical contact, lack of consent, and the relationship between the individuals involved. Here, the defendant's own statement confirms those elements. By admitting that he grabbed the victim and pushed her head down intentionally without permission, the defendant satisfies the legal criteria for the offense. That's why judges ask very direct questions during plea hearings. They are not looking for detailed stories or emotional explanations. They simply need enough information to confirm that the defendant's conduct fits the legal definition of the charge. Domestic violence cases are particularly serious because they involve personal relationships. The law recognizes that violence within relationships can escalate over time, which is why courts often impose additional conditions like counseling, probation supervision, or protective orders. It's a reminder that even actions that may occur during heated arguments can quickly cross into criminal territory. And it raises an important question: should courts focus more on punishment in domestic violence cases or on intervention and rehabilitation? Because preventing future harm is often just as important as addressing the incident itself.
And Ms. Boone, what is she to you? Ex. She's like
Okay. Okay. You have a dating relationship or an intimate relationship. All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor, we will satisfy.
Defense satisfied, Your Honor.
Court will accept the defendant's. Court will accept the defendant. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be. What I'm going to do is I would normally sentence him in August, but I'm going to push it out after presumably everything's done. And then we may try to combine all of the sentences.
So September 11th is next.
That'll get us there. Sentencing will be September 11th, 2023 at 9. That, I'll put that via Zoom at this point. All right.
It'll be in the afternoon.
At 1, that's right, because we're switching those. 12 o'clock noon. Thank you. All right,
Your Honor, could we address bond?
you may.
Just because he has been in, I think, 63, 65 days, something like that, over 60 days on that bond violation, Your Honor. And given that we're going to be out to September, I know there are other things here in the global resolution. I don't know that there's any particular reason, given the agreement, why he couldn't be given a PR bond or at least released on some sort of bond. Again,
Now the courtroom moves into a completely different type of discussion, bond and pretrial detention. The defense attorney argues that Mr. Carter has already spent more than 60 days in jail due to a bond violation and is requesting some form of release before the next hearing. Bond decisions are one of the most challenging aspects of the criminal justice system. Judges must balance two competing priorities: protecting public safety and respecting the defendant's right to remain free until sentencing or trial. The defense proposes several possible conditions, including a GPS tether, which would allow authorities to track the defendant's movements electronically. These kinds of monitoring systems are increasingly common as alternatives to jail while cases are pending. But prosecutors push back, raising a serious concern. The defendant allegedly continued contacting the victim even after restrictions were put in place. That's a major red flag for judges. Violating court orders or attempting to contact victims while a case is pending can dramatically affect how a judge views a defendant's reliability. So the debate here isn't just about time served. It's about whether the court can trust the defendant to follow the rules if released.
Your Honor, we would have no problem with tethers, any other kind of mechanisms by which the court would feel confident.
Well, I don't know that that's going to make much sense to do, only because he's not going to be released on the other matters.
Is he, my understanding, at least from last time, was that this was the only thing holding him in the jail. The felonies, I'm pretty sure he's not, and I don't know about the child abuse.
Using on the other ones.
Yeah. I thought on his felonies, he had some type of,
So one felony does.
one felony has a personal.
And he says he has a $500 bond on the child abuse.
Child abuse is a $500 for 5,000, 10%.
Right. There should be two felonies, I thought, yeah. Is it two cases or just
I
one?
think it's just one, that's all.
You only see one case for him?
Well, the felony, I don't see the one. But it has multiple charges.
They're together.
So you may have more charges.
They're together.
Yeah, I think that he's been charged, I believe, with felony R&O and felony fleeing and eluding. I think from the same nexus.
Yeah, and I see that all in one case.
They're all in one case.
Yeah.
Okay.
Your Honor, that's correct, but may I address?
Yes.
I'm going to object to any reduction in bond at this point. My understanding is that as of late July, he had his phone privileges revoked, but was continuing to call the victim from other inmates' pins still. So I don't have confidence that if Your Honor does release him, that he is going to follow bond conditions. So I'm just going to ask that the bond remain the same, at least he's actually on his remaining cases.
He assures me he will absolutely abide by any orders court gives.
He told me that a couple of times.
I know, Your Honor, but he's had a lot of time to think about it, though, Your Honor. He's, and he also understands that there are these felony charges now on him as well. I've come to know Mr. Carter quite well through the course of this case. He is a smart young man. He does plan on going to Washtenaw Community College. He was pursuing the job. He is trying to get his life back in order. And again, he would gladly accept a GPS tether, any other sort of thing that you would have to have, Your Honor, to feel confident that he would return.
Do in this case is the motion for bond reduction I'm going to deny with this caveat. That is, the court will, upon motion, reconsider this after the 25th of this month after the final felony cases come through. And may look toward having a PSI done before I would change anything, just so that we're sure where he's at and what he'll be doing. So I'm not saying no, I'm just saying I need more information at this time, and I want everything to go through for Mr. Carter before we do anything.
And what would you need from me, Your Honor, to?
If I just, it doesn't have to be a detailed motion, just some motion after my understanding is he's gonna enter those pleas on the 24th. So
At the
it
P-
just needs to be raised by the 25th, and then we'll try to
All right,
see
so-
and address it.
So after the.
You may want to also, because you had the PD on the other matters, right? You may want to coordinate with the public defenders on those cases so that maybe even at the time, I'll change this date to the 24th.
Okay,
And then that way, maybe they can raise it.
on the record.
Everything can be raised at once it's done that.
All right, I'll contact the PD's office, let them know what happened here today, and let them know
Okay.
about that.
So I'm not saying no, I'm just saying let's see where everything's at.
Thank you, Your Honor.
All right? Thank you.
Judge Simpson's decision here reflects a cautious and measured approach. Instead of granting immediate bond reduction or rejecting the request outright, he chooses a middle ground. Deny the motion for now, but leave the door open for reconsideration. This type of ruling often happens when a judge feels there isn't enough information yet to make a final decision. The judge specifically mentions wanting to see how the pending felony cases unfold before reconsidering bond conditions. In other words, the court wants the full picture before making a decision that could affect public safety or the defendant's liberty. It's also worth noting that the judge suggests coordinating with the public defender handling the other cases so that everything can potentially be addressed at the same time. That's another example of the court trying to streamline the legal process while maintaining fairness. When multiple cases are involved, judges often prefer to evaluate them collectively before making major decisions like release or sentencing. So as this hearing wraps up, we've seen several different legal processes unfold in the same courtroom session. Property destruction, assault, domestic violence, and complex bond discussions involving additional felony charges. Each case highlights a different aspect of the justice system and the careful balancing act judges must perform every day. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.